Hello friends, welcome to Inside Psych Initiative. In today's video, we are going to discuss about Supreme Court judgment related to electoral bonds. You all know that Supreme Court given a judgment that electoral bonds are unconstitutional in nature. In this context, we will try to understand various dimensions regarding the electoral bonds. So mainly, we will discuss about what are electoral bonds and how the electoral bond works. After that, we will discuss about what are the main contentions, okay, what are the issues raised before the Supreme Court and what are the Supreme Court observations. First we have to understand that, okay, then we will discuss about some other details regarding pros and cons of the electoral bonds and how electoral bonds evolved and what kind of laws amended in the process of implementing electoral bonds, that everything we will cover. So first we will try to understand what are the major issues argued before the Supreme Court, or major issues introduced before the bench. We will try to understand. So the context is Supreme Court struck down electoral bond scheme as unconstitutional, okay, as unconstitutional because it is violating various important fundamental laws. Okay, which fundamental laws we will discuss anyhow. 5 judge bench, that means the bench includes 5 judges. They are CJI D.V. Chandrachud and Honorable Justices Sanjeev Khanna, R. Gawai, J.B. Pardiwala and Manoj Mishra. These are the 5 judges. You know students, the minimum bench strength required in any constitutional matters, it will be 5. But there will be in another situation also, there will be 5 judges. In which condition? There are two conditions in which the bench should contain minimum 5 judges. One is regarding the constitutional matters. What is the other condition, other situation? Okay, put your answer in the comment section. So the issues, mainly the following issues raised before the Supreme Court. The first issue is whether the electoral bond violating the right to information or not. Okay, first issue, listen, first issue, okay, issues raised before Supreme Court, issues before Supreme Court. What are those issues? Issue number 1, whether electoral bonds, I am just writing the short forms, whether electoral bonds violating Article 19(1)(a). So this is the first question. Here you have to understand there are certain fundamental rights in our Indian Constitution. In such fundamental rights, right to freedom include Article 19, 20, 21, 22. In the right to freedom, one article is about Article 19. Article 19 giving various types of freedom to us. Okay, such freedoms include 6 types of freedoms. Article 19(1) to Article 19(1)(g). Okay, now we are not going into all those freedoms. We will confine our discussion mainly to right to freedom of speech and expression. Right to freedom of speech and expression. Right to freedom of speech and expression. Okay, this article also includes the meaning of, okay, the right to information. Right to information also covers under this provision. This was the Supreme Court interpretation. Okay, Right to Information Act was enacted in the year of 2005. You know that. So right to information is one of the element which is inherently present in Article 19(1)(a), because without information you don't have the freedom to speak on various things. Now these electoral bonds, they are stopping you from knowing the source of funding to the political party. That means electoral bonds are encouraging the lack of transparency. Okay, lack of transparency, because of electoral bonds, lack of transparency. So this lack of transparency is completely against the right to information, that is right to transparency. So on these grounds, Supreme Court invalidate the electoral bonds. This is the first reason, number 1. Okay, the first issue is it is completely against the right to information, and Supreme Court also believed that electoral bond is all about what? Okay, electoral bond simply it is about, okay, getting bond paper from SBI, same like how we take DD in the bank, demand draft. Electoral bond simply we will purchase from the SBI, and on this bond does not contain the donor name, no donor name, no donor name, and this bond paper will be deposited in the political party account. Party account. Okay, party account. That means political party don't know how much money they are getting from the people. That is clear. But the point is, the only entity which is knowing the information here is SBI. Okay, from SBI, government can easily know the information. This is about the selective transparency. That means the information is getting available to only particular people. That is the major concern here. And even the RTI is filed. These donations, they are, like, you don't know who the money is giving. You know only about how much money you got through electoral bonds, but you don't know who the bonds given to you, because the parties also don't know. For example, if I file an RTI about, for example, Communist Party of India, how much money they got through electoral bonds, means they will tell whatever the money they got, but they don't know who given that money. They don't know who given that money, because all the data is with only SBI. Okay, that SBI data can be accessible only to the government. That is a major concern here. Now, who are giving the bonds here? Who are buying the electoral bonds? Electoral bonds generally they are buying by the industrialist. Okay, industrialists. Then what is happening when a particular capitalist is buying the electoral bond and donating the political party? Obviously, the political party will give certain forms of concession in the form of policies, in the form of the schemes, or in the form of the incentives, or in other different forms. So this is the one of the issue highlighted by the Supreme Court. Okay, there may be a quid pro quo. There may be a possibility of quid pro quo between the capitalist and political party. So that political party, political parties can be influenced by the capitalists. That means economic inequality may leads to political inequality as well. This is the gross violation of the objectives the Constitution wanted to achieve. Next, issue number 2. So can we support the electoral bonds on the name of the curbing the black money? Okay, that is also the issue. That is also the issue examined by the Supreme Court. Issue number 2. Issue number 2 is electoral bonds introduced to reduce the black money. Can on these grounds, why can't we support the electoral bonds? But again, so the intention to reduce the black money on the name of this initiative, you are putting restriction on what? You are putting restriction on Article 19(1)(a). Okay, on what grounds actually you can put restriction under Article 19(1)(a)? You can restrict Article 19(1)(a) only on the grounds mentioned in Article 19(2). Okay, but here the black money is not the ground mentioned in the Article 19(2) to restrict the Article 19(1)(a). So that means you cannot restrict the application of Article 19(1)(a) just on the name of the reduction of black money, because there are other initiatives also there. For example, you can make a law that no party should get more than 20,000 anonymous deposits. Like that kind of initiatives also can improve the political funding, can improve the transparency in the political funding. You can put the reasonable restrictions. So this reducing the black money, on the name of that you cannot put restriction on Article 19(1)(a), because the cost benefit ratio, the trade-off you would like to achieve is not the cost benefit ratio. That is what Supreme Court observed. Issue number 3. Supreme Court also examined that these electoral bonds are leading to unlimited funding. Of course, this apprehension is also true, because nowadays in politics, this crime and politics are deeply embedded. In these times, there is no surprise that people are giving unlimited amount of the money to the political party, and in return they are getting that kind of concessions. So this may lead to unlimited funding as well. By examining all these facets, okay, Supreme Court clearly mentioned that electoral bonds are constitutionally invalid. Now, by the way, we'll try to understand some basic information regarding the electoral bonds. Who can sell the electoral bonds? Only SBI can sell the electoral bonds. What is the shelf life of the electoral bonds? 15 days. And this electoral bonds through these electoral bonds, money can be donated through only to registered parties under section 29A of Representation of People's Act 1951. And what is the period of this purchase? In the month of January, April, July and October. That means in yearly only 4 months. In only 4 months, in the 4 months also, in specific 10 days, these electoral bonds are allowed to be purchased. And electoral bonds can be purchased in the multiples of 1000, 10,000, 1 lakh, 10 lakh and 1 crore. A person can or a company can buy any number of electoral bonds. There is no restriction on that. And there is no name on the electoral bond also. It is a bearer instrument. If a financial instrument does not contain the name of the buyer, it is known as bearer instrument. Who are eligible? A citizen of India or any body like any corporation eligible to buy the electoral bonds. And the KYC details will be with the SBI bank. And if a person unable to deposit the electoral bond into the party account, then the money will be deposited to this PM CARES fund. According to the data, highest amount of the money through electoral bonds is received by the Bharatiya Janata Party, next Congress, then TMC, then BJD, like so on and so forth. So these are the various issues regarding the electoral bonds. Regarding the data, I shown the data from the Association for Democratic Reforms. Electoral bonds, these financial instruments, it is an instrument, it is introduced in 2018, mainly to control the black money, to facilitate anonymous political donation. Okay, now I would like to ask one question to you. Okay, if the political donations have become public, if everyone knows about their funding, then don't you think the political affiliations of the individual will be open to everyone? That may lead to the discrimination by a ruling party. Don't you think that can also be possible? What is the solution for that? What is the solution for that? And donation can be given to only registered political parties. Then Article 29A, whichever the political parties registered, to them only the money can be given. And by the way, what is your opinion on this judgment? What is your take on this? Okay, whether you are agreeing with the same apprehension, or do you have some other apprehensions, or do you think electoral bonds serve the purpose? And available denomination 1000 to 1 crore, authorized bank SBI only. SBI, we discussed all these things, in which months they can be sold. And for the introduction of the electoral bonds, following acts were amended: Income Tax Act 1961, Companies Act 2013, FCRA 2010 and the Representation of People Act 1951. All these are amended in Financial Bill 2017, that is Financial Act 2017. Through that act, these legislations were amended to facilitate the introduction of the electoral bonds. The reason behind introduction of the electoral bonds: encouraging the digital transactions, anonymity of donors, formalizing the political contributions and enhancing the transparency. These are the various objectives behind the electoral bonds according to government. Criticism: lack of transparency, already explained how it is justifiable. Potential for money laundering, unlimited money, anonymous donors, obviously clear open shut case of political laundering. Unusual advantage to ruling party, obviously in any case ruling party has advantage. Bypassing the election commission scrutiny, and finally no upper limit on funding. These are some of the criticism. So this is about the electoral bonds. Now let's see yesterday's video question. Which of the followings are not mentioned in the Constitution of India? Which are not mentioned? Let's see. Council of Ministers mentioned. Collective responsibility, both are mentioned under Article 75 Clause 3. Resignation of ministers not mentioned because they will be removed by the President. Office of the Deputy Prime Minister not mentioned. Now let's see today's question. Consider the following statement with regard to the electoral bonds. Electoral bonds can be given to a registered political party which is either a national party or state party. Although called a bond, the banking instrument resembling promissory notes will not carry any interest. It won't carry any interest, it is saying. So pick the right one. Mains question: whether electoral bonds are effective in ensuring fair, justice and open elections. Discuss the various concerns regarding the electoral bonds. What are the various concerns regarding the electoral bonds? This is a mains question. As we reach to the end of this video, in this particular video we discussed about how the electoral bond functions, what are the issues raised before the Supreme Court, what are the observations, and final verdict of the Supreme Court is electoral bonds are unconstitutional in nature. That is what we discussed. And we also discussed about some technicalities regarding the electoral bonds, such as their denominations, who introduce the electoral bonds, who can sell the electoral bonds, to whom the electoral bonds can be sold, merits and demerits of the electoral bonds. So this is the detailed analysis regarding the electoral bonds. I hope you understood this concept in a detailed manner. Thanks for watching this video. Have a great day. Jai Hind.